OIC. Our Secretary General is unable to join us today due to another official engagement. However, he has asked me to convey his sincere appreciation to our distinguished speakers, as well as to all of our participants for joining us today. For our July webinar, we are delighted to be partnering with ISTIN Attorney Partnership. I would also like to extend our sincere thanks and a warm welcome to Dr. Ismail Isin and Ms. Demet Kasharcıoğlu. The topic of today's webinar is M&A disputes in international arbitration, which aims to explore the practical and strategic aspects of M&A arbitration through the lens of current practices and real-world experiences. Now, before I hand over the floor to our moderator, I would like to briefly mention that today's webinar will run for approximately 1 hour and 15 minutes. The presentation will be followed by a Q&A session, and we encourage you all to submit your questions throughout the webinar using the chat function. Finally, I would like to share that we have some exciting news that we look forward to announcing in the near future. We encourage you all to continue following the OIC Arbitration Center for updates and future announcements. Now, without further ado, I will now hand over the floor to our moderator, Ms. Demet Kasharcıoğlu. Thank you very much, and I hope you enjoyed today's webinar.
Thank you, Anya, and thank you to our participants. Welcome on board. My name is Demet Kasharcıoğlu, and I'm a disputes partner at ISTIN Attorney Partnership, and I'm going to moderate today's session. And I would like to thank the organization of Islamic Cooperation Arbitration Center for having us today. And my guest speaker today is Dr. Ismail Isin, and I just want to briefly introduce him to you. Dr. Ismail Isin is a partner at ISTIN Attorney Partnership, where he co-heads the firm's dispute resolution practice. With almost 30 years of experience, Ismail advises domestic and international clients on a broad range of matters, including arbitration and litigation and mergers and acquisitions. He regularly represents leading Turkish and multinational companies before local courts and international arbitration tribunals, acting under the rules of various arbitration institutions. In addition to serving as counsel in complex arbitration and litigation proceedings, Ismail frequently acts as an arbitrator with particular expertise in disputes arising from mergers and acquisitions. Alongside his practice, Ismail has lectured at several universities in Turkey and has authored numerous publications on mergers and acquisitions and dispute resolution. And his most recent books include Mergers and Acquisitions, which is this one. This is the book for our practice, and Borçlar Hukuku Genel Hükümler, which can be translated as Law Obligations General Provisions. So, thank you, Hocam, for joining us today. As you understand, we have been working with Ismail for a very long time on M&A disputes particularly, and it's been like almost 15 years, right, Hocam?
At the age of 10.
Thank you. So this webinar will be a bit like an apprentice interviewing his master, exploring the lessons learned, experience, and the insight gained over the years.
And she promised me not to ask difficult questions, so I'll do my best.
But you can ask. Please put your questions in the chat box. I'm going to check along the discussion, and I can also ask those questions during our discussion if you allow me, Dr. Isin.
Sure. So from time to time, you will see that we are not looking at the camera because we are in the same room. We can look at each other. So don't be surprised. So we are here, we are looking at the camera, but sometimes you will see the difference. Thank you very much for inviting me, for attending this conference online, to all the participants, and the OIC Arbitration Center for inviting me to this event.
Okay,
Ready?
So M&A disputes have become one of the fastest growing areas in international arbitration, and yet M&A and disputes sound like two completely different things to me. Because
two different words.
Yes, because on one hand, when we think of M&A, we think of growth, opportunities, and deal making. But on the other hand, when we think of disputes, we think of conflict. But when these two concepts come together, they create a unique type of dispute. That's why I think it makes sense to start with M&A itself before we move on to disputes. And since M&A is one of your area of expertise, I'd like to ask you what M&A is.
What is M&A? In 2 minutes. Yeah, M&A is a corporate transaction in the end, and so basically you buy a business or you sell a business. So it's a complex economic unit, and drafting an agreement to transfer this, to define this, is not an easy thing. And yeah, as you said, the transaction itself and the dispute arising out of the transaction are in a way different words, but the players are the same people in many cases. The parties are. If you have watched the Matrix movie, the transaction lawyers are like Neo. They have sunglasses, nice hairs, and nice coat, and they can even fly. They can fight in a great way, and they can stop bullets, everything. This is the world of the transaction. Good looking, and you are the flying guy. And M&A disputes is the real world in the Matrix movie. You have taken the red pill, and you have very short hairs. You have a very silly pullover. You have to eat very bad-looking food, and all the time you are under attack. So in the end, these are two roles are played by the same artist, but in a very different way. So I think this is the most important and most striking position between the M&A transaction lawyers and the dispute lawyers. What is M&A? M&A is a very sophisticated thing because a lot of details. You have to go through a due diligence process. You have to draft the agreements for ages, long nights, negotiations, every detail. And in a regular M&A transaction, the draft agreements and back and forth between the parties are. So my highest number was 54 versions of one agreement, one share purchase agreement. 54 versions were exchanged, and in each of them, a lot of changes in it. So a long negotiation. So the investment bankers, the auditors, the tax advisors, the business advisors, too many people in one room spend days and nights together, exchange drafts, and then they come to a conclusion, which we call share purchase agreement or the shareholders agreement or other ancillary agreements. So nowadays, if we are talking about a share purchase agreement, a straightforward one, we are talking about 40, 50 pages. So when I was younger, it was 20 pages, 30 pages. So it's getting every day more extensive and more detailed. So if I have to explain, and maybe it brings us to the next stage in our conversation. What is M&A? M&A is a very sophisticated thing, and the legal framework is as sophisticated as the transaction itself. People have many advisors, try to think about everything, try to cover everything possible in an agreement, and then come to a conclusion. Okay, I pay you the money, you give me the shares. So in the end, it's not just the paper, printed paper, printed share on paper. It is the business, the subject of paper is the business itself. And of course, each and every transaction is different from the other. The business dynamics are very different from each other. And it's a very detailed documents.
Thank you, Hocam. I was going to ask how the transaction documents typically negotiated and drafted, and you kind of mentioned that several versions of the drafts are exchanged, but since we've been working for so long, I know that you pay particular attention to the risk assessment.
Yeah,
So-
I will talk about the 5 items in an M&A transaction in drafting. First of all, it's a long negotiation process. It's not like, okay, let's bring some provisions together. Okay, this is the agreement. No, it is a very detailed and long procedure. So they go in every detail. It takes a long time to come to a conclusion and several drafts. So these are the 3 very typical items. Because there is no business without risk. In the end, the parties try to assess the risk, calculate the risk, and manage the risk. And they have to be smart in that. So non-risks are irrelevant for the M&A transaction. Sometimes I have the experience that the lawyers discuss, even fight over non-risks as if they were, because they have learned something and they want to repeat themselves. In one transaction a year ago, the company is a factoring company in financial business, in finance business, and so they only offices, nothing more. And we were representing the sellers. The buyer's lawyer insisted on environmental impact reports. I said, this is an office business. So how on earth are you expecting environmental reports that there is none? And the colleague insisted on a representation and warranty item about the environmental issues. And I said, why? And she said, we do it all the time like this. I said, but this is not the same business. Anyway, sometimes the lawyers stick on non-risk as if they were one. And the risk calculation, of course, very important. So there are 2 components in it: the probabilistic calculation and the impact calculation. Sometimes the probability that risk will occur is very low. However, if that once occurs, the impact is very high. So you have to make the calculation on both sides. And finally, and I think most importantly, is the balance between the parties. The agreement tries to bring the parties' interests acceptable to the parties at a certain level. So the balancing the interests, because if I'm selling the company, I want to make sure that I will receive my money at some point. Sometimes it's during the closing itself. Sometimes there are earn-out provisions, sometimes price adjustment provisions, liability provisions, etc. The seller wants to secure basically 2 things. First, I sold this business. I don't want to have any other problem out of this transaction, first. Secondly, am I gonna get my money paid? And the buyer's interest is basically, okay, I'm paying money for this business, and I have certain expectations, and I have to make sure that my expectations will come true by this transaction, because I'm paying for something. And that something must be in my control after the closing. So in the end, the parties try to balance their interests and, more importantly, expectations. I think this is the most critical part for the understanding of the arbitrators. Why on earth the people have agreed on this agreement? Because in the end, the agreement is the law, the written private law, special law of the parties. So looking at provisions of law, etc., shouldn't be the first thing because they have drafted their own law under the agreement. So I think this is the most critical part of the agreement. May I go into the expectation part here? How the arbitrators should look at this agreement. Because I have problems with many arbitrators and they know it. The recent case, the one case, I'm happy with it. Very reputable tribunal, an ICC case. But sometimes arbitrators try to find or try to reach a fair conclusion from their perspective. Excuse me, this is not your job. This is not the arbitrator's job to come to a fair conclusion what is in their mind. I'm sorry to say that. That is the biggest mistake in I've seen it on many occasions. Even in the tribunals, I was sitting arbitrator. The parties have negotiated their balanced deal. If you look at a certain level of the provision and try to apply a fairness test to that provision, you disregard the following. In many cases, I can say that as a transaction. Sometimes you give in at some point in order to get another advantage on another. So this is a give and take, because you ask, how is it negotiated and drafted? This is a give and take situation. In an M&A transaction, you negotiate, if not more, at least 100 items. Really, you can discuss and negotiate on 100 different items. In some of them, you accept the counterparty's position, and in return, you say, okay, I have accepted your position in this provision, and you have to accept my position in the other provision. And this is how the agreements is concluded and signed and closed. And later on, from one of those provisions, my example, one in the favor of seller, the other one provision in the favor of the purchaser, and out of one of these provisions, a dispute arises. And sometimes the arbitrators say, oh, this is a very harsh provision. It is not fair. The purchaser or the seller has been put under pressure. We should, in a way, soften this provision. No, this is the wrong approach, because why that provision is drafted like that is because of a very simple reason. They have agreed on that. I, as arbitrator, have nothing to do but to apply the agreement to the facts at hand. That's all. The arbitrators should really avoid fairness tests if they try to come to a conclusion in M&A dispute. Why I'm saying especially M&A dispute? Because M&A disputes are very sophisticated, very balanced, and very well negotiated, very detailed documents. My job as arbitrator is never to make another round of fairness tests to the provisions of this agreement. I have to apply the agreement one by one and one to one.
Well, actually, this is a type of situation where we faced several times. And actually, that brings me another question, because this is something typical in M&A disputes. And I was wondering whether it is because of lack of M&A experience on the arbitrators.
Yes, that's the biggest problem. I see counsels and arbitrators acting as counsel and arbitrator in M&A disputes, which have never been in a data room in their whole life. They have never seen how an agreement is negotiated. I heard several times from arbitrators that the arbitration clause in an M&A transaction is 11 o'clock provision. No, not at all. I have never seen that. I have never seen that litigation or arbitration, what should apply to this dispute, this item has been negotiated by the end of the agreement. No, on the contrary, it is there from the very first document, which is LOI, letter of intent, or term sheet. They have a picture, many arbitrators and arbitration counsels have a picture in their mind which does not reflect the reality. That's a very big problem. That makes the M&A arbitration a big problem for the parties because they have signed this agreement with a certain provision. In a recent case, the arbitrators really says ICC arbitration, large enough, a great tribunal, academicians and practitioners as in the tribunal, very reputable, very honest people, but they gave a reasoning in the award that the parties have mistakenly provided or agreed on certain item. I'm terribly sorry. It can never happen in a transaction where giant companies on both sides, and which was the case in this dispute, and you were one of my podcasts too. Giant parties, large, very professional M&A firms, 20-something drafts back and forth. You cannot come to a conclusion based on your mistakenly understanding. This is the biggest mistake. And no one has raised that any provision was concluded mistakenly. Really, so we're talking about professors, reputable international arbitration experts, etc. The mistakenly word was itself mistake, a very big mistake. So it didn't bother our position, but I was very sorry for my colleagues. Really, they have no idea, absolutely no idea what is an M&A transaction. You cannot put something mistakenly, however, sometimes I see transaction counsels in the transactions as M&A counsel. They are afraid of many things. Maybe we can come to that later on, but in drafting, they love it really. For the avoidance of the doubt, I love it. All my cases, all of my experience, if there is for the avoidance of doubt statement in an agreement, believe me, that was the source of the very dispute. Because the transaction lawyers are trying to repeat themselves. Don't do it. That is a very typical drafting mistake. In one of the cases, I was arbitrator in the same provision only, the same article. They have stated something, and then the next paragraph says, for the avoidance of doubt, again defines the thing from the other angle. But it is not the same. So one party insisted the first paragraph is the right thing, and the arbitrator has to apply the first paragraph. And the other party was saying, no, the other one was the right one. I came to the conclusion, if there is a for the avoidance of doubts phrases in the agreements, I think the second one after such phrases should be preferred by the arbitrator to apply, not the first one. Because if I read that, they have agreed on something and they were not sure what they have agreed on, and they agreed again to rephrase it once again. And then the second should prevail, and that was written in my award as well.
Well, obviously, after 30 years of experience, you have plenty of war stories, Hocam.
Oh,
But at the same time, I do hear that the importance of having an M&A background, and taken from there, I believe there must be something that an M&A practitioner can bring it to the table. But I was wondering what that specific purpose is. For instance, is it an understanding of how the deal was structured and how those specific provisions were drafted in the way they were? Or is it an awareness of the agreements must be applied to the specific facts of the case rather than reinventing the balance of the parties.
Absolutely. Janet, remember your earlier days in this firm. I asked you to work with the arbitration, with the M&A team for how long? 3 years?
Yes, 3 years.
You have spent those whole 3 years as a member of the transaction M&A team.
Yes.
And you have seen what is a due diligence, you have seen how is it crafted, you have seen how the annexes and schedules are prepared. You have seen everything in those 3 years. Then I took you back to the dispute scheme back after all that experience. Now you can analyze a dispute, an M&A dispute, much better than many arbitration experts because you have seen how the agreement has been drafted. So my sincere recommendation to everyone, especially to those young practitioners, spend some years, not just one transaction, two transactions, 1 to 2 years at least, in the M&A teams of their firms, and vice versa. By the way. If you want to be a great transaction lawyer, try to spend 1 to 2 years at least in the disputes team. As I gave the example in the very beginning, the Matrix movie issue, if you are doing just transactions, you have learned to prepare to draft a nice looking agreement in your nice looking office with other nice looking people. But the real world is out there. The real world is if things do not develop as foreseen, as agreed, or as expected. If you have that experience that things can develop in a different way than written on paper, okay, what's next? If you have the disputes background and experience, you can draft much better provisions because you know how it will be read in case of a dispute. And more importantly, as disputes lawyer, you see what can be the source of a dispute. And if you know that as a transaction lawyer, you can avoid such problems. So you don't stick on non-issues and spend too much time on non-issues, which I've seen as an M&A practitioner very often. Am I talking too much?
No, I was just thinking of my junior days, and thanks to you and Eren Kurşun, our now managing partner, really helped me to develop my expertise in both M&A and M&A disputes now. And in fact, it really helped something else as well, which is, where to look, what questions to ask, and then which documents matter most, and even preserving all the documents exchanged during the due diligence phase so that you can fulfill your burden of proof in case of a dispute. So not only understanding the dynamics, but also how to take a position during a dispute phase.
Absolutely.
So it really helped me. And that actually brings me to another question. And we all understand that having an M&A background expertise has a real value. But do you think that an M&A lawyer who leads the deal should also be the leading counsel in the arbitration arising out of the same transaction?
Yeah, great question, Demet. By the way, the answer is in the book.
Again,
Promoting
for those who not present at the beginning, this is the English version.
Yeah, the title is the teamwork. The team wins. If you want to win a dispute, you have to learn to act as a team with the in-house team, with the technical team, with the transaction counsel as well. So in many cases, if a dispute arises, the parties go to their transaction counsels because they have drafted the agreement, and the parties' expectation is that who has drafted the agreement is the one who is best positioned to solve the issue as well. I made that mistake in my in early days of my career. I was 34, 33 years old, I think. I was still young. So
You're still young.
thank you, 25 years old.
Your experience.
So that was one of my transactions. I was together with my mentor Gerhard Wigman on the transaction side, large public company, Turkish public company transaction. We were representing the foreign purchaser, etc. The transaction was closed, and then the dispute arose. And of course, we started to draft some memoranda for the client, etc., and to draft the statement of claim. And that was almost midnight. I was sitting on my desk, working on the draft, and I said, okay, hold a second. I'm not defending the client's interests. I'm defending my agreement. What does it mean? Very simple. There is no perfect agreement in this field. I haven't seen anyone who has seen that either. So in the end, in order to win the case, you have to make a good analysis of the case, including what the agreement says. Of course, the transaction lawyer wants to believe that his or her agreement is a great one. In order to win the case, you have to see the weaknesses in your agreement as well. And you will not be able to see that. It's like the parents looking at their child. If you look at your child, you basically see a great thing, but they are never perfect. So in the end, you need a more professional look at the agreement. And I will definitely keep the transaction lawyer on board in order not to miss anything if I were the client. And I would never, ever give the leading counsel role to my transaction lawyer. He or she is the support lawyer to the lead counsel. But the lead counsel should be another one. I'm not saying an arbitration expert. I'm not saying a disputes expert. It can be an expert of M&A as well, okay? But the lawyer who has drafted and negotiated the agreement should not make the judgment call. After years, and you were with me in that case, Demet, you will remember, out of an M&A transaction on which I was the lead transaction counsel, a dispute arose. The client insisted that I lead the arbitration as well. And I said, under one condition, I will not be the one who will make the judgment call and who will decide on the strategy of the dispute. And we asked the Turkish practitioners who know the name very well, Haluk Burcuoğlu. We asked Haluk Burcuoğlu to be the lead counsel in the dispute. And I was the support counsel. And I did the right thing, I believe, because the transaction counsel loves his or her agreement, his or her work, and cannot be 100% objective under many circumstances. Maybe some may, but it's very difficult. I will go into that risk. I will definitely pick up someone, transaction lawyer or arbitration lawyer, doesn't matter, as lead counsel if a dispute arises, and keep the transaction counsel who has drafted and negotiated the agreement on board as part of the team.
Actually, that's a very valuable insight, Hocam. We have been actually following this approach for many years, but very recently I have seen a multinational company who adopted this approach as a company policy. They approach us and they specifically mentioned that by policy, their company cannot retain the transaction counsel as the dispute counsel.
Really?
Yes. Yes, I'm going
didn't know that.
name
Very smart. Very smart.
after this webinar. I'm sorry, due to the confidentiality constraints, I cannot give the name, but I'll tell you who
Yes.
is. But that's
So I'm
something
not
where no, and this is the policy, by the way, and they cannot,
Perfect.
change rules. But it's really good to see that we have the common understanding on that. So just I want to move a little bit on the type of disputes, because you mentioned that M&A has its own life cycle. That's a very long journey, and it has different stages. And it's always possible, to see different type of disputes throughout the negotiations. And at least for today, I want to ask you what type of disputes are most common ones today, because there are typical disputes of breaches of representation and warranties, purchase price adjustments, earnouts, disclosure issues. But I was wondering whether there are any sources of conflict. And if you may, there is one question that touches upon to this question. One of our participants wishes to explore more uncommon type of disputes, because this is a question, I'm just quoting. The M&A transaction is easy if the transaction happens in the same country. But if it is a cross-border transaction, it becomes a more sophisticated one,
I can see.
needing more approvals from Capital Markets Authority, disclosures in stock exchange, and depositing the shares in the depository house, and more technical expertise in the capital markets of the country and its jurisdiction. And it needs arbitrators specialized in the capital markets disputes and cross-border regulations. Could you give examples regarding uncommon type of disputes and cases of M&A in arbitration? So I was just asking a more common one, but this one is specific.
First of all, I can say more than 90% of my M&A transactions were cross-border. Either the purchaser or the seller or the target company were somewhere else. So in the end, that is very common. So domestic M&A, I have done some, to be honest, but not the vast majority was cross-border anyway. Does it make things more difficult? Culturally, sometimes. Regulation-wise, yes, maybe, but I wouldn't say that just by being cross-border, the transaction becomes more difficult. The expectation and the level of sophistication of the parties, that is the problematic. So I have worked on domestic transactions, 100% Turkish buyer, Turkish seller, and Turkish company. I have done some of them as well. There, the biggest problem is to explain to the parties that this is a sophisticated transaction and that they had to go into details on many items. And so, if I have to speak from the Turkish perspective, and in many cases, both Turks say, "Oh, the lawyers are trying to make things overcomplicated." No, this is the international standard of an M&A transaction, but they want to make things easier, faster, etc., etc. And in the end, they are increasing the risk of dispute arising. This is why I say, so I don't see a big difference between, in terms of legal issue, and in terms of the expectations and the level of sophistication of the parties. Yes, we experience the problem that the parties want to make it faster, easier. Don't stick on that. We know the other company very well. He's my good friend. So we had lunch yesterday. and we see each other, so they will not create problems to us. I give you an example without giving the party's name. Fairly large transaction. The purchaser, one of the big groups in Turkey doing business, made an investment. Both parties were friends for the last 30 years or so, and that 30 years was 60% of their lives. Okay, they have spent 30 years together as very good friends. They made an investment, and guess what happened? You don't have to guess, you were part of that deal. After a year, after a big fight, the investment came to an end. So in the end, the parties try to make things easier, but there is no easy M&A transaction. With regards to capital markets, etc., if you are talking about the regulatory sides of the transaction, from the M&A perspective, of course, there are necessities to deal with during the negotiation, etc. But in terms of M&A disputes, once the deal is closed and without a tender offer, etc., I see a smaller risk of the capital markets regulation creates a post-closing dispute, unless the call option, put option issue, etc. So of course, but this is a very uncommon one, and I don't want to use my airtime for very uncommon issues, but for our colleague who wants to go into more detail, very happy to discuss. But if I look in general, of course, since it's all about money, the earnouts, purchase price adjustments are important things, and in many cases there is a problem. And of course, don't think only about the share purchase agreement. If you have acquired a minority or majority share in a company, you become a partner with the counterparty. Sometimes 50-50 partner, sometimes majority, sometimes minority. A shareholders disputes arise sometimes. And there, the biggest problem is, for instance, so in my experience, one of the parties tried to take the company as a hostage. Especially the minority shareholders love it, because if you are a minority shareholder and if the company's value is decreased by 60%, only your minority melted by 60%, but the majority's value was much higher, or money was or stake in this company was much higher. 60% of that is more than that. This is another issue. So the shareholders dispute are, from my perspective, more critical for the company, more critical for the parties than the SPR. Because in an M&A transaction, among others, you have two main documents. If it's a partial takeover, share purchase agreement, it's a one-off agreement. You pay, you get the shares. Full stop. It's over. Okay? But the shareholders agreement is a continuing relationship. So as long as you are shareholder in the company, even for some provisions, even after your exit, you are bound with the provisions. Non-compete, for instance, non-solicitation, these are very critical provisions as well. The put option, call options, tag along, drag along. Okay, put option is easier to exercise. You exercise your put option and you ask for the money. But if you exercise your call option, that means give me your shares, I pay you the money. And the enforcement of that call option is always difficult in real world. So coming back to your question, the most common ones, I think the shareholders agreement disputes like non-compete, put option, call option, drag along right. Drag along right is a very interesting position as well. So in the end, you say to your minority or majority shareholder, okay, if I want to sell my shares, I will take yours as well, put together with my shares and sell it to a third party, and then we will share the proceeds. And especially the private equity funds prefer that because if they are minority shareholder in a company, and if they want to make the best value out of this investment, they want to be in a position to sell a majority share to a third party. Let's assume you are a private equity fund only with 30% shareholding in a company. No one will buy your 30%. But if you can sell 51, 60, 80, or even 100%, you can sell to a better price. And you participate on the majority price or majority pricing with your 30%. But how can you take the money from shareholder, your dear fellow shareholder, and sell to a third party? If you don't have an escrow, you will have difficulties for it. But there are always ways to get out of the difficult situation. Representation and warranties, many people think this is the most common source of dispute. In my humble experience, no. Since the representation and warranties are very detailed parts of the agreement and very detailed negotiated, so in my experience, not even 1/3 of the disputes I have seen as counsel or arbitrator was based on representation and warranties breach. But the purchase price adjustment, earnouts, put call option, tag along, drag along, are, for me, these were more common. Reps and warranties is to a large extent easier. In mergers and acquisition, in representation and warranty breach, the critical part is the burden of proof. How can you prove the amount of your damage? That is the critical thing.
Yes, Hocam, thank you. You explained in a very detailed manner, but at the same time, we have a follow-up question. And the specific question relates to the industry. Our participants would like to know that whether there is any particular industries
Can be anything.
that generate more M&A disputes compared to the other industries like energy, banking, finance.
Maybe there are statistics on that I'm not aware of. If I look at the last 30 years, can be anything. It can be frozen food, ice cream, or metal industry, or aviation, or you name it.
Thank you, Hocam.
It can be anything. So the disputes are always out there. They're waiting for us all the time to pop up. I cannot give a specific industry. For instance, private equity funds don't like disputes because it takes too long for them. Because if there's a dispute, I tell you one thing. So I told that some years ago in a conference. So to the best of my knowledge, arbitration is the second best way of dispute resolution. The second best way. Well, I don't know which is the first best way. I think the best way is the negotiation and coming to a common sense conclusion between the parties. Because if the parties have smart lawyers and smart decision makers, I still believe the worst settlement agreement is better than the best arbitral.
Thank you, Hocam. Conscious of time, I have still some critical questions that I want our participants to have your insight. So we'll talk about the type of disputes, and from there, I just want to move on to the forum selection. Because when we look at the market,
Arbitration and litigation.
yes, exactly, and one of the questions.
No doubt.
Why is that?
Come on, if you are so talking from the Turkish perspective. You have done several M&A transactions. What was the shortest share purchase and shareholders agreement you have ever seen? 30 pages, 40 pages,
Yeah.
50 pages, without annexes and schedule.
Yes.
The body of the agreement. Yeah. And in many cases, cross-border, in many cases, in English.
Yes.
And you expect from a judge sitting in the court, dealing with at least 20 hearings a day, you want him or her to read, understand, evaluate the evidences, and come to a conclusion in a type of agreement which he or she has seen probably for the first time in his or her life, versus three people, fairly experts. I had some problems with them as well. No doubt. No doubt. I will never go to any court, anywhere in the world, with an M&A documentation in my hand. Never.
So the priority is the expertise, and then the speed. At least this is why I hear from you.
Tell me why not arbitration in M&A?
Please.
Give me one good reason. Why not arbitration?
I don't know, maybe
You will prefer litigation over arbitration.
isn't it
Give me one
possible
good reason.
for, when an urgent interim relief is needed, or let's think of evidence collection.
You can do that.
Yes, but
If you have arbitration clause in your review, you can still get support from the courts for the interim relief, for the collection of evidences. You can do that. No one stops you.
but it's very difficult, when you have to have that approved by the arbitrators and then go to the Turkish courts and explain that. Don't you think it's a little bit easier, at least for Turkish practice? When you have a litigation, you can always provide your evidence for it, but for the evidence that you do not possess, you can just ask the court, send the writs, and collect all the necessary evidence. So it's kind of a practical, so to say. Don't you think so?
No.
Okay.
Absolutely not. I can do the same by going to arbitration or referring to arbitration, and I can still use the access of the courts if in that particular country, especially the model law, is followed. I don't see any problem with that. Really, I give you another example. So being old means you have seen a lot. I think that was 20 years ago. Approximately maybe 19 years. Funny enough, there was a M&A dispute in front of Turkish courts in Istanbul, not answer, in Istanbul, commercial court, and both parties, counsels to litigation, agreed that me and another professor shall be appointed as experts to make an evaluation on the file. Okay? Even for us to prepare our opinion took us, I think, 10 months or so. 10 months, just for the opinion. And believe me, the opinion didn't conclude everything. After our opinion, the court continued, as far as I have learned from both parties' counsels, another 3-4 years in front of the first court of instance. And then there was no court of appeal yet. That was court of cassation level only. It took another 2 years there, and then it came back to the court of first instance. Come on, an M&A transaction dispute should not survive that long, because time is money for the enterprise. It's not selling a glass of water. It's a business, and the arbitrators should be smart enough to keep the business safe from the parties' attacks too. Right.
Well, there is a similar, concern coming from the audience as I just asked you. The question is, wouldn't seeking assistance from the courts during arbitral proceedings more difficult than resolving the entire dispute through litigation? After all, many courts do not even seem to be familiar with the arbitration or how it works.
I doubt. I did it a couple of times. That was not a big issue. First of all, especially within the last 10, 15 years, thanks to the arbitration centers in Turkey, thanks to participation of the judges in the arbitration conferences. In the recent one, we were together, as you may remember, in Itotan.
Mhm.
Half of the audience were judges. You remember?
Yes.
Judges from members of the Court of Cassations, members, even chair of the 14th Courts of Court of Appeals. They gave a conference. I see in ICC conferences members of the Yargıtay, Court of Cassation, as speakers or people in the audience. I wouldn't say that the judges are totally unaware of against the idea of arbitration. On the contrary, and that has changed in the last 20 years gradually. But I would say, especially within the last 10 years, maybe even 15 years, the move in terms of mindset of the judges to support arbitration is getting stronger and stronger. That's my personal experience with the courts. As I said, I've been in front of the courts asking for collecting evidence, asking for interim reliefs, and so their approach was very positive.
Thank you.
But I cannot, of course, assure that each and every judge has the same understanding,
Of course.
unfortunately.
We cannot make the same comment for the arbitrators either, so it's something
I tell you one thing,
special
the
for
judges
each
are
case.
very happy with the fact that the arbitration works well because those cases are very sophisticated for them and they don't want to be part of that game either. And in terms of cost, so in Turkey, the court costs is quite high, really high. And if you are talking about a high value dispute, every institution in this world is cheaper than the Turkish court. I swear.
Yes,
If you are
yes,
talking about $100 million dispute,
I cannot make the calculation right now, but there's a comparison which I believe
in the book.
Istanbul are. Yes, it is in the book as well, and this is something that Istanbul Arbitration Center also explains throughout its presentations. Make a comparison between the institutions and the Turkish courts costs. So it is something worthwhile to check before choosing the forum during the negotiations. So let's turn to the arbitration process itself. As you mentioned, M&A disputes are quite complex. We know that, especially when it comes to valuation and quantum issues. And in those type of cases, both parties provide their own expert reports, which usually conclude totally different things. So
they have to.
So what is your preference? Do you believe that this is something worthwhile? Or would you prefer to appoint your expert, like the one in the courts, because the court appoint the experts, you only have one panel, one conclusion? Which one is your preference?
I have only two experiences where I, as arbitrator, or we as arbitrators, appointed experts. In the first case, I have appointed an expert not to prepare an expert opinion report, etc., but to help me to understand the expert opinions submitted by both parties. Okay, and he was very useful. He was not an expert in that sense. He was the advisor to the tribunal to help to understand what were the opinions or expert opinion reports. In another one, yeah, it was not my preference, but the rest of the tribunal concluded that the tribunal should appoint a board of experts. That made things even more complicated. Conflict of interest is an issue. Fee structure for the expert is another issue. Independency is another issue. I prefer not to appoint an expert by the tribunal. Having said that, of course, as arbitrator, I need to understand the case in order to come to a conclusion. And I know well that the experts are paid advisors in the end. So, yes, they are. I don't have anything against the side. But the critical thing is the following. Sometimes the experts believe they know everything and the arbitrators know nothing. In one case, and you were my secretary in the
Yes.
tribunal, I really had to ask the party appointed expert to leave. I said, I will not ask any further, because it was our turn to ask questions to the to understand to the expert. He was thinking probably that the arbitrators and lawyers are idiots and have no understanding of mathematics. So that was really a very bad experience with an expert. He was very well educated, very reputable, probably well paid. Not probably, because we have seen his invoice. And that was the winning party's expert. We didn't grant that expert's cost in the award. That was a very clear message. So the experts have to be smart enough to think that the arbitrators are not idiots. If they start to think in this way, they harm their own party. So a special expert who says everything, yes to everything, does not help to the party he or she is working or advising. I think that is a very critical thing. In another one, in a recent case, we were party counsel, as you may remember. The expert has mixed up Turkish lira and dollars and applied Turkish inflation ratio to US dollars. And he defended his position and he made himself really unreliable in front of the tribunal.
Well, the council should be cautious about appointing expert and their expertise and what is written in the report. As you
Yeah, but
said,
the
that's
experts are very
an
important for us to understand because it's burden of proof. What is that? 5 minutes left, Ola.
Yes, and I have two questions. We are sitting in the second room, and I'm trying.
Stick to that. Okay, I stop you.
I'm just trying to manage. So please complete your sentence, Hocam. I just didn't want to interfere. Just wanted to remind in time. But
So in the end, the experts have to be very careful. So saying yes to everything told by the party is not the right thing for an expert. On the contrary, the expert has to, if the expert wants to help the party, then the expert has to warn the party, don't do that. No one will buy this story.
yes.
For the burden of proof, quantum experts are critical, very critical. As long as they internalize that the arbitrators are not idiots, they will make their job much better.
That will be helpful. Thank you. And we are about to close our session, and I just to wrap up questions. And the first one is without specifying the discussing the specific matters, of course. What distinguishes a successful M&A claim from the unsuccessful one? You already mentioned some kind of mistakes, but maybe just to, wrap things up, do you believe that there are recurring mistakes that the parties tend to make?
Hmm. So first of all, you really have to analyze. That sounds maybe ridiculous, but really, by reading the submission as arbitrator makes me think the following. You have to make sure that you understand what is your claim. Everyone who said, of course I know what is my claim. Excuse me, in many cases, so I can say they are not aware. Are you claiming damages or performance for us? This is a very critical thing. If you claim damages, yeah, then you have to put on the table what was the obligation, how it has been breached, what was the consequence of such breach, and what is the effect of that breach in terms of quantum.
In my experience, what I see is, hocam, counsel asking payment of some monies and let the tribunal to decide whether it's a damages claim or performance.
Sometimes the subject of performance and subject of indemnification,
Specific indemnity.
the
Compensation.
performance itself or the damages are money sometimes. But it doesn't change the fact these are two different characters. The burden of proof changes. For instance, if you are claiming the performance, the fault is not important as long as I'm speaking from the Turkish law perspective, as long as the performance is still possible, the claimant can demand the performance anyway, irrespective of the default, irrespective of anything different, as long as you define what is the obligation, and that the obligation is not performed, you can claim the performance. You don't have to deal what is the fault, what is the causal link, etc. Because in performance there is no causal link. It's performance only. Well, I've seen on some occasions parties claiming performance and dealing with the items of damages, which is absolutely irrelevant for the case. And what is the consequence? You write hundreds of pages about irrelevant items. Maybe you are right in everything, but it doesn't change anything. So the relevance test is another thing that the council should make. And of course, in one case, that was very interesting. The claimant was claiming compensation based on 22 legal grounds. 22, I swear, 22. All was zero success. You know what happened? We, the tribunal, found by chance in the file somewhere hidden that they were right with the 23rd legal ground, and they won the case. So that is sometimes the lawyers, so good lawyer, good counsel, bad counsel, they are lost in small details or irrelevant details, and they have to focus on the what is my claim, what do I have to prove, and how can I prove? I think that is a very step-by-step and simple analytics. So when I was young, so there was a great Dutch player in the World Cup. After the new World Cup, we can mention Johan Cruyff. He was saying, football is an easy game. The difficult part is to play football in an easy way. So I think we have to make, we don't have to answer everything. Sometimes by way of tactic, the councils put unnecessary thing on paper in order to trigger the counterparty to deal with those irrelevant items. And if you are lost in the irrelevant items put forward by the counterparty, you start to lose the case.
It's because of a diligence strategy, or maybe sometimes parties interfering too much on councils when they're drafting, because it's their business. And as you said, M&A transactions are quite delicate and unique, and we're talking about the business. So sometimes clients also want to, put all those information in
Yes,
submissions.
the clients, I want to look like Brad Pitt for the clients. The clients wants to have everything. Yeah, that's the client management, client relation issue. It is not easy, to be very honest. I know, I appreciate all the colleagues, but as a professional, you have to manage your clients' expectations as well.
Thank you, John.
So otherwise, you are lost in the details of the counterparty or even your own details.
So we ran out of time, but I just have one quick question just to wrap up, because you are wearing all three hats: M&A lawyer, arbitration practitioner, and arbitrator. And I just want to ask you one advice to give the audience. For instance, what should transaction lawyers keep in mind when negotiating and drafting M&A agreements? And on the other hand, what should the arbitration council focus on when handling M&A disputes?
Wisdom to the transaction lawyers by drafting and negotiating. Be smart and make things clear in the agreement. And phrases like for the avoidance of doubt, etc., does not clarify anything. Draft things only once and in the right way, rather than trying to. Recently, I read an agreement, fairly large. There were, I think, 4 or 5 for the avoidance of doubt provision. That is absolutely wrong. Do it once and make it clear. And of course, don't forget, as a transaction lawyer, so it's a risk assessment, risk calculation, risk management issue. And that has to be reflected in the agreement and make your agreement readable and understandable. So that is the recommendation to the transaction council. For the arbitration councils, make a good analysis. Keep the transaction council on your side. Try to understand from him or her the entirety of the agreement, the concept of the agreement, etc. You need, as dispute counsel, you need the transaction lawyer working together with you. Don't try to kill his reputation. Don't try to. I've seen that too, right? Just remember where you were the secretary to the tribunal, and I was acting as the chair recently. Demetri, we have seen both parties, transaction counsels, in front of the tribunal explain what happened during this negotiation.
Yes, you're right.
As you may remember, so especially one of the transaction counsels, he was. I was very sorry for this colleague, really. So he felt bad. He felt bad because probably he has been really badly treated by the disputes council. So that was my impression. I cannot know that.
Hopefully it was not like that. So we just felt sorry about him, but we need to be cautious about it.
Don't forget, mistakes happen. I haven't seen a perfect agreement in my entire life. The agreements I have drafted, they include mistakes, I'm sure. Mistakes I have identified, mistakes I have not identified yet, maybe. I haven't seen any agreement without any mistake. But it has to be acceptable, and even making a mistake is another risk. which should be assessed, calculated, and managed.
The best thing is, I think, is to face with that mistake and think about how to cure it. You say it like the first step to cure the mistake is to admit that you made a mistake.
Yeah. You have to admit that you have made a mistake if you have to deal with that mistake. Yeah, that's absolutely correct. And just remember, so that let's share it with the audience as well. In our practice, we finalize the draft submission, and then we ask someone who has not worked on that matter at all to read the submission and ask this person, what did you understand from the submission? And they explain what they have understood, put that on the whiteboard, and then we see, okay, we wanted to explain these 10 items, and only 7 of them are well understood, 3 not understood at all, and there are other 2 items which have been misunderstood. Then we have to reshuffle the document and make sure that all 10 are well understood and nothing is misunderstood. So you have to ask the assistance of your colleagues which have not worked on this method, I believe.
Thank you, Hocam.
Ayalım, thanks very much. So I spoke too long, maybe. And
I
thanks
know
for
we
your
appreciate you. So thank you so much for such an insightful and engaging webinar, Dr. Esin and Ms. Kaşarcıoğlu. We
you.
greatly appreciate your time, expertise, and valuable contributions. And again, thank you for your support in making this webinar possible. And if that's the closing of our webinar, I would also like to thank all of our participants for joining us today. And unless there's anything else, I would like to just say I'd look forward to welcoming all of our participants for future events and wish you all a pleasant day. Thank you once
Thank you very much for inviting me.
again. It was an absolute pleasure.
Thank you. Bye-bye.